laws. Every law must be enforceable. We should be able to enforce laws, and these law enforcement agencies should also play their role in such enforcement. So that is why we are saying that laws, one of the characteristics of laws is that they must be what? Enforceable, such that when somebody violates it, we know that the person will either pay a fine or the person will either go to prison or both. Secondly, our laws are supposed to be what we call rule-based. Rule-based simply means that every law is based on a certain framework, which are rules, and these rules are applied to help us resolve conflicts or any kind of misunderstanding within the social system. Because at the end of the day, we are to maintain law and order. So there must be rules. Rules simply means that there should be consistency in the application of the laws. If somebody commits A and another person also commits the same A, there's the same rule that apply to A should apply to B. That is what we mean. Additionally, we are also saying that laws must exist to protect the rights of individuals. You can imagine if we are in a country and we have laws, but these laws are not protecting human rights. They are not protecting anybody's rights. You can imagine how people will be trampling upon people's rights. Politicians, for instance, will just be abusing people just like that. When you walk into your offices, which I'm sure most of you are working, you have your managers and your directors abusing your rights. And so these laws exist to protect our rights, such that when you are laid off or your contract or your employment is terminated unduly or unlawfully, you can have a cause of action against the organization. We are also saying that laws should exist to what? To bring about social cohesion. Even though the laws are there and we are saying that when people commit certain offenses, they are supposed to be punished, they are supposed to be doing this. It all exists so that it will bring about social cohesion. So that when you know that you step on arduous toe, this will be the punishment, you will not do it. And so you would rather stay calm and then at least relate well with Adra, knowing that when you do A, B, C, D, it will land you into trouble. And so these laws are all passed so that people will behave in a certain manner that is consistent with what? The rules and regulations of our constitution or the rules and regulations within society to enhance or to ensure that people live comfortably within the social setting. Additionally, we are also saying that laws must be predictable and there should be certainty in our laws. Predictability simply means that once the law is there, if it is applied to this person, when this person steals and the person goes to jail, or the person steals, let's say, 10 million, and we know that 10 million stealing is a second-degree felony, which is likely to take somebody to prison for about 10 to 15 years. We should also know that if another person commits a similar offense, the law should be predictable. It should tell us that once another person commits similar offense, he or she is likely to also get what? 10 to 15 years. So you are able to predict what will happen if you do otherwise. That is what the laws are supposed to be. Because if a law is not predictable and then one set of law is being applied to a different person, and then the same set of law is also applied to different persons in different ways, then we will not have any kind of predictability of our laws. And there should be certainty also as well in our laws. The laws must be certain. If it is A, it is A. If it is B, it is B. We are not going to turn A into C and then B into D. There must be certainty in our laws. Now, we are also saying that there should be what we call limitations of law. Limitations of law. even though we are saying that laws are very important and they play key roles in our society in ensuring social cohesion, there are certain limitations that must also be applied in terms of our laws. For instance, we have the law that when somebody trespasses on your property, you can take action in court. But there is also another limitation to that same law, which says that if you allow the person to trespass on your land and you watch this person for 12 years and you take no action, you yourself, as the owner of the land, you will be restrained. That property or that land will be taken away from you. These are the kind of limitations so that people don't behave in any other way. If you have a land or if you have a property, you must protect it. If you allow somebody to occupy it for 12 years, limitation would catch up with you. And you cannot take any action in court. Any action that you commence in court after 12 years will just be to nothing.
Yeah. Hello.
Yeah, yes.
Hello. So please, can you share with us your screen? Your screen, your point.
My point. Yes, I'm saying limitations of law.
Sir.
No, I'm
Yeah.
talking of the screen sharing.
At the screen.
The slide, yes, please.
Oh, okay. No, I am not speaking from any slide.
Oh, okay. Okay.
Yeah.
Thank you, sir.
But I believe you have your manual with you.
Yes, please.
Yes. So I am lecturing directly from the manual.
The manual, okay. Yes, please.
Yes.
Thank you.
Okay. And the last point that we will be looking at under the characteristics of law is what we say that there are legal systems and jurisprudence. Legal systems simply means that, I mean, it's a framework that directs how countries or how states operate, or how the laws of a state operates within their own settings, because every country has its own laws. The jurisprudence of every country is different. In Ghana, we operate on the common law system. But you go to other countries in Europe and in Russia, and they are operating what we call the civil law system. And so legal systems are different. Jurisprudence, even though there are laws, they are also different. So these are some of the characteristics of law that we want to look at. Now, having moved into legal system, the question now is, what is legal system? And we are saying that legal system is a structured framework within which laws are created, interpreted, and applied. And so you have Ghana as a country. It has its own legal system. How are our laws created? Our laws are created through parliament. It is the parliament or the legislative body which comes up with the law, which passes the law. And these laws are then interpreted. Interpreted by who? They are interpreted by the judiciary, which is the courts. And so you have these forms or these governmental bodies, okay? So we have the executive, we have the legislature, and we have the judiciary as the three core arms of government. And this is how it works. The executive, which, I mean, you all know, has the presidential powers. The executive will be appointing whoever, the various ministers, blah, 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 blah. And then when it comes to parliament, which is the legislature, they are also mandated to pass the laws. And we have the judiciary who are also mandated to interpret the law. Now, the executive commences the process of the creation of the law. And don't forget, these same executives are the ones who are going to enforce the law. Because don't forget, enforcement of the law are within the remit of the police and other state institutions. And these state institutions are controlled or regulated by the executives. That is why the president will be appointing the IGP and whoever, because they are mandated to ensure that the laws are enforced. Parliament's role is to ensure that laws are passed. And then the judiciary's role is to ensure that the laws are interpreted in a way which will be consistent with our constitution. And so our legal system, like I said earlier, we operate on the common law system. And common law simply means that normally we say common laws are laws that are common within a jurisdiction or within common law countries. And so normally you would have the Commonwealth countries, okay? You have UK, you have Australia, you have Ghana, you have what other countries? We have Ireland and all those countries. You have these countries using the common law system. Common law simply means that when a law or when the judiciary of these common law countries, when they pass or when they come up with judicial decisions, those judicial decisions can be taken into consideration in Ghana. And that's why we are saying what they are common. It has a history from the ancient Greek Roman times up to date. But for your purposes, I am not going to go into how common law came about. But common law simply means that laws that are common within these Commonwealth jurisdictions. Such that if a Supreme Court in England makes judicial pronouncements or comes up with a judgment, even though in Ghana we are dealing with what we call our constitution and has nothing to do with theirs, it becomes a common law which is applicable in Ghana here. It is not mandatory, but at least it is persuasive enough for a competent court in Ghana here to apply similar decisions. That's why we are saying they are what? Common laws. Now, we want to look at the component of our legal system in Ghana here. In Ghana here, the component of our legal system, one, has to do with our legal professionals. The legal environment is just like a market. Like you go to Agbogloshi or whatever market. When you go, you see market women. You see people who are trading in tomatoes. You see others who are truck pushers. You see a whole lot of. So that is a market. So our legal system also operates like what? Like a market. So we are saying that within our legal system, what can we find? What are the parts, okay, the components within our legal system? That is what we are looking at. And we are saying that the first thing is that we are seeing legal professionals. And legal professionals, we are not talking about only lawyers. We are not talking about only lawyers. We are talking about solicitors as well. We are talking about law lecturers. We are talking about scholars. We are talking about writers, people who matter in the administration of justice. They are legal professionals. Another component of our legal system is our court system, okay, or our judiciary. The legal system has to is also comprised with what? With our judges. It comprises our judges. Because if you have lawyers and you do not have judges, then how are you going to operate? So we have judges who are also part of the legal system. Now we also have what we call institutions. These institutions are also part of our legal system. And one core institution, we are looking at what? The legislature. We are looking at our executive agencies, because they are part of the laws. They are part of the creators of the law. So they are part of our legal system. Because if Parliament if Parliament does not pass the law, then we will have no law at all for it to even operate in our system or in our country. And if the executive also do not originate the law, we will also have no law to also deal with. So our institutions, which comprises the legislature and our executive bodies, play a key role in our legal system. Another group of people who also play a key role in our legal system has to do with law enforcement agencies. For instance, the police. Because you can have the courts, which are central. You can go for the interpretation of the laws. You can go for anything, do your adjudication, whatever. But at the end of the day, it is the implementation of the law that is important. Because if Parliament passes the law, it has to be implemented. So that when somebody commits an offense, the police must implement what? The law. By catching that offender and presenting that person before a competent court. And lastly, we are also saying that another component of our legal system has to do with the laws and regulations. These laws are embodied within a certain system. And so when you look at Article 11, okay, Article 11.1 of the 1992 Constitution, it tells you the sources of law. Don't forget, Article 11.1 will tell you about the sources of law, where we are getting our laws from in Ghana. And it tells you that the key source of our law is what? Is the Constitution, Act of Parliament, which are also what? Statutes. It tells you about existing laws. It tells you about our customary laws, laws of equity. It tells you about legislative instruments. These are our sources of law, where we can get our laws from. Judicial precedents also as well, because they form part of the common law. So don't forget Article 11.1. And so within the Ghanaian jurisprudence or within the Ghanaian legal system, these components must work to ensure that all the laws that we have within Ghana operate to serve the purpose for which everybody within the country exists for. So the judiciary plays key role. I've already said that. And in the judiciary, you know that it includes the Supreme Court from the top to down. We have the Supreme Court. From Supreme Court, we have the Court of Appeal. From the Court of Appeal, we have the High Court. These are the superior court. So we say they are called superior courts. So the superior court starts from the High Court to Court of Appeal and then to Supreme Court. And then we have what we call the lower courts. So the lower court, we are talking about the circuit court, we are talking about the district court or the family tribunal. These are also deemed or termed as the lower court. And their responsibility is to do what? Is to adjudicate cases. They are to interpret the law. If there is, how do you call it? If two or three people are placing different meanings on one law, you have to go to court for an interpretation. If people don't understand anything about a certain contractual relation, you have to go to court for an interpretation or for an adjudication. So the court play a key role in whatever we do. Any questions so far?
No, sir.
Okay, so then I am continuing.
Okay, sir.
All right. So within the Ghanaian legal system, like I've already said, we have different kinds of laws that regulate us. And the legal system we have, we cannot do away with what? With our legal education system. The law schools in the country also play a key role to produce lawyers to fill what? The markets. Because if law schools are not there, we are not going to have lawyers. If we are not going to have lawyers, then we are not going to have judges. If we are not going to have judges, then we are not going to get anybody to adjudicate or interpret our laws for us. And if you are not getting anybody to adjudicate our law, our issues for us, then what it means is that there's going to be chaos. Then it will be about a survival of the fittest. If you are strong, then you push your way through. But insofar as we have such a legal system, it is not just for the strong. We have what we call also customary laws in our Ghanaian legal system. And customary laws, simply, they play a key role in whatever we do. Normally, these are laws of customs in our society. Ghana comprises of different ethnic groups. It comprises of different individuals. And all these places have their own customs. The Akans have their own customs. The Ewes have their own customs. The Achems, whoever, they all have their own customs. So customary law also play a key role. Because customary law will then tell us that if there is an inheritance, who should inherit who? If there's an inheritance in the northern part of the country, who should inherit who? If there is an inheritance or anything else within a certain ethnic group, then what should be applied? Because you cannot apply a customary law from Akan to Ewes. It doesn't work like that. Everybody has his or its own customary laws, and they operate differently. So customary law plays an important role also within our jurisprudence. And we have our constitutional law, that is the mother law, the law of all laws, which is the constitutional law. Having gone through the Ghanaian legal system, then I want us to take a look at some core areas in law that we have. Even though I've already highlighted some, I want us to look at some core areas of law, of legal practice that we have in Ghana here. And the first thing I want us to look at is criminal law. Criminal law, mostly it deals with offenses against the states or society. And so we say that these offenses are mostly punishable. See, anybody who comes in conflict with the law or anybody who offends the law, we say the person offends the state. So even though I may have engaged in a certain fight with somebody and assaulted the person might have picked up injuries. So for instance, let me use Benjamin and Joyce as an example. Benjamin has an issue with Joyce, and because he thinks that he is stronger than Joyce, what he does is to beat up Joyce. So Benjamin beats up Joyce and Joyce gets hurt. What we say is that Benjamin has assaulted Joyce. What he has done is not just an assault against Joyce, it is an offense against the state. So that is where criminal law comes in. Once you would have offended the person, but the person is of no interest here at this point. It is the offense against the state that we are interested in. Even though Joyce can take Benjamin on a different level, okay, we call that civil. The state will be interested in what Benjamin has done to Joyce. Why? Because the state wants to ensure that there is law and order within the society. Because if the state does not come in, then it means that tomorrow Emmanuel will also go and beat Sarah and he will go scot-free. And so such offenses are against the state. So any criminal offense or any offense that any person commits against the state, we say it is what? A criminal offense. And criminal law was put together to ensure that there is public safety, so that there is no threat to public safety, so that nobody can just go about and be doing whatever he or she likes. There has to be order and society. That's the essence of criminal law. So the laws are there to ensure or to regulate people's behavior so that people do not trample upon people's rights anyhow. Other than that, I will just be there. I can just pick a gun and then go and shoot Richard, or I pick a gun and then go and shoot James or whoever. Okay, but criminal law will tell you that if I pick a gun and shoot somebody else, what have I done? I have offended the person. And what offense is that? We are saying that offense is what? Murder. And so I must now go and face the state. There is also what we call punishment for offenders in criminal law. The offenses may vary. You could have a fine, you could have imprisonment, you could have even both. Okay. And so it depends on what the law has made provision for. If the law says drug trafficking is an offense, then it's an offense. If the law says that drug trafficking, when you are caught in drug trafficking, your punishment should be 2 years to 4 years, then that is what you will be given if you are found guilty. But where the law has not provided for an offense, it means that when the person commits something, I mean, the person cannot, nothing can be done to the person. An example is adultery. So you ask yourself, is adultery a crime? No, adultery is not a crime. It's not a crime. Why? Because it has not been provided for in our statute books or in our laws. And so when you engage in it, I mean, nobody can do you anything. The police officers, whoever, cannot come to arrest you because they say you've engaged in adultery. No, it is not an offense because it is not provided for in our statute books. So in criminal law, it is only offenses that are prescribed in our laws, okay, that a person can be punished for. If the offense is not provided for in our laws, nobody can do you anything. Secondly, if the offense has been provided for in the law, the offense must go with what? Its corresponding punishment. So there could be an offense in the law, but the law has not made room for punishment. So I have committed the offense, but the law did not prescribe for any punishment. You cannot do the person anything. Because if you intended it to regulate people's behavior, you would have provided the punishment. So these are the two key things when it comes to criminal law. And you would also hear in criminal law, you'll be hearing mens rea and actus reus. Mens rea and actus reus. Mens rea simply means what? The guilty mind. And actus reus also simply means what? The guilty act. What it means is that before a person can be convicted for a criminal offense, both the mens rea and the actus reus has to be present. If the mens rea is present and the actus reus is not present, you cannot convict an accused person. Similarly, if the actus reus is present and the mens rea is not present, you cannot equally not convict a person. So I don't want to go into detail, but I mean, yes, because this is not a pure law class. It is just for you to understand what the meaning of mens rea and actus reus is. There is also another branch of law which we call civil law. Civil law simply means that these are disputes. I mean, these are disputes between individuals. Okay, so it could be a dispute between Ofosu and Joyce, or Philemon and Sarah. So these civil laws seeks to regulate individual behavior. And in civil law, we are talking about laws such as contract, okay, laws in relation to property, laws in relation to employment, laws in relation to divorce. You see, these are issues that happen on an individual level. It can be Ofosu, okay, against an agency or an institution or a state, or Ofosu against a different person. Once it has nothing to do with crime, we say there are civil laws. So civil laws are laws other than what? Criminal law. And then within the civil law, normally you would have what we call within the civil laws, we have different branches or different categories of civil law. So we have contract law, we have private law, we have international law, we have whatever, constitutional law, we have all sort of laws under it. And so we will be going briefly also into these kinds of civil laws. But mostly in civil law, which are laws that governs individual behaviors or individual relations with one another, normally when a person breaches such a law, what happens is that you take the person to court and the person is likely to pay compensation to the individual. So for instance, with the example that I gave on assault, Benjamin assaulted Joyce. The state is interested in it, so the state can pick it up as an offense against the state. Equally, Joyce can equally sue Benjamin on a civil level and then go and claim what? Damages or compensation from Benjamin for slapping her. These are different. If the state picks it up, Joyce will not get anything because it is the state that has picked it up. So normally in criminal cases, you hear the Republic versus Benjamin Ofosu, or the Republic versus Sarah Avo, or the Republic versus so and so. And in the civil matters, that's where you hear Ofosu Benjamin versus Joyce, okay, Philemon Chamber versus Sarah Avo. When you see all those things, then it means that those are civil cases because it is between the various individuals. And in civil law, you are looking at what? Damages or compensation, because that is the remedy that you are looking for. You could also have remedy, we call it equitable remedy. Equitable remedies such as injunction. Injunctions are more or less like restraining orders, to restrain somebody from doing something. Somebody is building on your land. Quickly, you must file a process in court and file an injunction application to stop or restrain the person from continuing to build on your land, pending the determination of the final matter. You could also have specific performance. Specific performance when you enter into an arrangement or into a contract with somebody else and the person is not performing his side of the agreement, you quickly go to court to enforce so that the person performs whatever agreement that you guys reached at the earlier stages. And you could also have damages or compensation. Now, there is what we also call public law. Okay, public law, as the name suggests, it is also a law from the civil law. Okay, like I said, we have just two core types, civil law and criminal law. But under the civil law, we have various categories within the civil law, under the civil law. So one I'm saying is the public law, and public law is the law that governs the individual and the government. So if an individual has a certain dispute with the government, then we are talking about public law. Then we also have what we call private law. Private law, that is if an individual has a problem or has a dispute with another individual, okay, or an individual has a problem or a dispute with an agency, with an institution, which is not a government institution, then we are talking about what? Private law. We also have what we call international law, as the name suggests. These are disputes, okay, or laws that governs different countries. So you could have laws governing relationship between Ghana and Nigeria, or Ghana and Cote d'Ivoire, or Ghana and the United States, or Ghana and Ireland. Once it transcends beyond borders, we say it is what? International law. And we also have what we call constitutional law. But before I come to constitutional law, international law, again, has to do with institutions beyond borders. So it is not always the case that international law has to do with only countries. So you could have an institution in Ghana, okay, having a dispute with another institution outside of the country. It is also international law. So sometimes you would have contract, especially a bank, let's say EcoBank enters into an agreement with, let's say, another bank in the United States, okay, it becomes international law. Once it transcends beyond the borders of a state, it becomes what we call what? International law. And there are specific laws that regulate the transactions of these, each and every party. So international law will come in. Once you are transacting a business in Ghana here with another company outside of the country, international law will come in. So you must know the laws that will govern that relationship. That is a key thing. And then fundamentally, we have spoken about the constitutional law. That is the law governing what? Our fundamental principles as a country. Any question? I am moving on. Any question?
Sir, please, my
Yes.
question is, the finance minister's own Oforiatta, does it
Okay.
fall under public law?
No, it doesn't fall under public law because we are not dealing with an individual and the government. You see, it is transcending beyond the borders of the country. So it is international law because it is between Ghana and the United States. And that's why we say, we normally say, how do you call it? So we have an extradition treaty with the United States. So normally these behaviors or these transactions are regulated by treaties and conventions. So you normally hear of conventions because you cannot have a law which will regulate or govern the behavior of a different country. As in, we have two laws. This law is governing Ghana, and that same law is governing, let's say, US. No, because US has its own laws. Ghana has its own laws. And so normally when they want to enter into a certain agreement or a certain relationship that will establish a certain relationship, there has to be what we call treaties and conventions. It is those treaties and conventions that will regulate the activities of the parties. So in the case of Oforiatta, it is going to be what? International law. And with this international law, we have what we call an extradition treaty. So Ghana has signed an extradition treaty with some states or some countries, including the United States, such that if somebody commits an offense here in Ghana, or the person commits an offense in the US, okay, and the person has to be brought from Ghana to US for him to go and deal with the offense that he committed, quickly, they can pick the person up and then extradite the person back to the United States to answer questions on the offenses that he got himself involved in. It is also vice versa. So if you heard of Abu Trike's case, the US quickly invoked the extradition treaty that they had with Ghana so that they could bring him to US for him to go and answer why he engaged in certain acts. And it is not just his case. I mean, especially most of the people who end up doing romance scams and all those things, because they have committed an offense in the US. So whichever country that they are, if the country has a treaty, an extradition treaty with US, they can quickly pick you up. But if the country has no extradition treaty with US, then it becomes very difficult because your laws will protect you. Is it okay?
Yes, sir. But so what of the Kennedy Japan and Anas case? The one they took it in US.
Yes, so the one that was taken to US had nothing to do with what happened in Ghana here.
Okay.
Okay? It had nothing to do with what happened in Ghana here. What happened in Ghana here was dealt with in accordance with Ghanaian law.
Okay.
And so you'd notice that it went through the High Court, it went through the Court of Appeal, and then to the Supreme Court, which ended it. What went on outside of Ghana was a different case, which was international in nature, said that Anas could take up the case internationally in the US. Because if something happened in Ghana here, he could not have taken it up to US because he feels that is where he would get justice. No, it doesn't work that way. So now let's move on. Okay, unless maybe somebody else has another question. Okay, so without any question, then I would move on. Let's move on to certain legal principles that is of importance that you need to understand. So far, we have done what we call criminal law. And one of the key principles in criminal law is what we refer to as the presumption of innocence. Presumption of innocence. Presumption of innocence simply means that an accused person is presumed to be innocent until proven guilty. Until the person has been found guilty by a competent court in Ghana here, the accused person has to be presumed to be innocent. He has not committed any offense. Even if he is taken, okay, the police arrest him. He has stolen this, he has murdered somebody, he has raped somebody, he has done this. And the police picks him and arraign this person before court. And this person says, I am not guilty of the offense. That ends it. If the person says, I am not guilty, it means from that moment, that person has to be what? Presumed to be innocent. That is why we are saying what? It is presumption. We are only presuming that the person is what? Innocent. Until we go through trial for us to know whether indeed the person did it or not. So every accused person is presumed to be innocent. Because if presumption of innocence does not work, then once the police catches you and arraigns you before court, it means you are guilty. And you know already with our police system over here, sometimes the way they behave, it is as though whether they have not been to school or they don't know how the law works. I don't know why. The first person who normally will go and then lodge a complaint at the police station, normally the police will say, oh, this person is telling the truth because he's the first person who came to lodge a complaint. and they will tend to treat the other person as if that person is a criminal. Okay, they end up even finding the person guilty. The other party end up finding the person guilty, pronouncing a whole lot of things on the person. At another point too, you go and lodge a complaint to the police. They are bribed, they are doing this, and then later on they will even turn the whole story on you. But the police is not the body or the person who is supposed to pronounce a person guilty or not. Your job as a police officer, a complainant has come to lodge a complaint. You lodge it, you investigate. If you think that the person should be arraigned before court because you have found elements of crime in what the person has said, all you need to do is just to arraign the person before court. Let the person go through the legal processes for the court to pronounce the person guilty, or for the person himself to say, I am guilty. So that is a presumption of innocence. When you arrest somebody, it does not mean the person has committed the offense. Because we have had a number of cases that people have been arrested by the police, they've gone through the judicial system, through the courts, and they came out as not guilty. Okay. But sometimes when they arrest you, it's more or less like you have even committed the offense. So that is the presumption of innocence. Once a person is presumed to be innocent, it means that every liberty that anybody who is outside of the, as in any right that any individual within the country has, that person must enjoy that right. The right to liberty, the right to walk freely, the right to do anything, the person should enjoy that right because the person is presumed to be innocent. He has not committed the offense. You may say he has committed it, but once a competent court has not found the person guilty, the person is what? Presumed to be innocent until proven guilty. There's another principle that you also need to know, which is what we call as the due process. Due process simply means that every person, any person, whether race, ethnic group, sex, whatever, that you are presented before any court, you are supposed to go through a due process. You must have what? Fair and just treatment. The processes must work for you. We must not have a different process working for the president of Ghana and then another process working for somebody who is a nobody. If there is a criminal procedure that every person accused of an offense should go through, every person should go through that. There must be a due process. Because this due process will ensure that the person gets fair trial. Fair trial means that the person must go through the required procedures as established by law. Every opportunity that a person needs, the person must get. If the person requires the services of a legal representation, the state is supposed to provide one for the accused person. That is due process. If a person is arraigned before courts and the person's plea ought to be taken, the plea has to be taken. You cannot just present a person before court and then you find the person guilty straightforward without asking the person whether he even understands the charges placed or preferred against him or not. Due process must be followed. If you take the person to court on a criminal case and the person says, I will speak Hausa, and at that material point in time, there is no Hausa interpreter in the courtroom, you must stop and go and look for one for the person to come and interpret it before you can proceed. That is due process. Everybody must have fair treatment. Justice must not be for just a few. It must be for all. Justice is about due process. If there's no due process, then there's no justice. We're also talking about what we call rule of law. Rule of law. And rule of law is a key principle in law, which means that everyone, I mean everyone, whether you, whether me, whether the president of Ghana, whether the president of whoever, must be accountable under the law. Every public official must be accountable to whatever he or she does. You are serving the interest of the people. You are serving the interest of the population. You must be held accountable to anything that you do. That is the rule of law. Because if the person is not held accountable to whatever he does, then equally there is no rule of law. The law that will be applied to John Mahama will be the same law that will be applied to Sarah. The same due process Mahama will go through is the same due process Sarah will go through in the event that they both commit a criminal offense. Even though we know that under our constitution, the president as it stands cannot stand trial. I mean, these are some of the protections that he gets. But assuming he's out of office, then the due processes would have to be followed, or the rule of law must be followed. There is also what we call equality before the law. And you should know the difference between equality before the law and the rule of law. Equality before the law, I mean, as the name suggests, equality. Everybody must be what? Equal. Whether you are a male, you are a female, whether you are rich, you are poor, whether you are a Muslim, you are a Christian, whether you are whatever, the law must apply equally to everybody. There is no specific law that is applied to the rich, and there's no specific law that is applied to the poor. Neither do we have a specific law that is applied to females, and then another law applied to males. All these persons are equal before the law. And if you are equal before the law, then we must all stand it. There is another principle that we call separation of powers. Separation of powers simply means that every organ of government, okay, or every arm of government has a function that it plays, and that one arm of government cannot play another's role. So the executive cannot go and pass law. They can only initiate the law. In the same way, parliament or the legislature, they cannot interpret the law. It is the duty of what? Of the judiciary. That's why we are saying what? Separation of powers. Powers and functions are separated. The judiciary plays its role. Legislature also play their role. And the executives also play their role. And all these three arms of government, there are checks and balances to control and regulate their activities such that executives do not abuse their powers. The same way that the judiciary will not also abuse its power. You saw what happened recently between the Chief Justice and the Republic. Okay? And so, even though the judiciary is there, it must be what? Accountable. The executive cannot play the role of the judiciary. But if there is a problem with the judiciary, then there are laid down procedures that can be what? Invoked for the president to what? To step in to correct those things. The same way, if the president misbehaves, Parliament can also step in to impeach the president. The same way, if there is an issue with the Electoral Commission, any of the independent bodies, the law has provided for what should be done. So that is what we mean by what? Separation of powers. Everybody plays its role, and there are checks and balances to ensure that everybody is what? Playing their role at one point in time. There is also what we call legal precedents as part of the legal concept that you'll be hearing. The name suggests what? Precedents. Precedent simply means that something that has been done earlier. And so here we are talking about cases. I made mention of common law. Common law fall in here with what? With legal precedents. So we are talking about decisions of courts. Okay. And these decisions of courts are supposed to be applied to cases, okay, of similar nature. So if I slapped Sarah and then the court held that the slapping was an assault, anytime another person also slaps a different person, automatically it becomes what? An assault. So legal precedents play a key role in helping us even predict what will happen. And we hear of what we call stare decisis. Stare decisis simply means that decisions of earlier courts, okay, decisions of earlier courts, and those decisions are applied for consistency purposes. That is why lawyers, normally we are reading what case laws, we are reading judicial articles. Why? We want to know what the Supreme Court said in case A, so that if another case or a similar case just like A happens, then we can go for that decision and apply it to it. That is what we mean by legal precedent or stare decisis. And the last one that we are looking at is legal liability. Legal liability, as the name suggests, liability simply means that who should be held responsible for what? Who should be liable for what? Because if you say you slapped Sarah, then we are saying that the liability should be on you, the person who slapped her. Okay, you should be held responsible for the actions or the omissions. The next thing that we want to look at is the legal professionals. Earlier, I made mention of legal professionals as individuals or as people playing key roles in our judicial system or in our legal system. Now, legal professionals, like I said, we are saying that these are lawyers or attorneys, and they play key roles in whatever we do to deepen and enhance the administration of justice. So what are some of the roles and responsibilities of our legal professionals? One is to have legal representation. What do? I mean, lawyers will obviously be representing clients when you have issues, when there are disputes, when somebody wants to cheat you. You have to have legal representation to help you when you want to sign a contract or any agreement, when you want to prepare a will, when you want to do anything that has to do with law. You must have what? Legal representation. So that is a key thing. Secondly, there has to be legal advice and counsel. Legal advice. So you go to the lawyer, you want to do ABC. The lawyer would have to advise you and tell you the implications of whatever you are doing. If you do ABC, this will be the result. Then you take your own decision. The lawyer does not take decision for you. The lawyer only advises you, for you, the client, to take a decision. So any decision that you take is upon you as a client. Legal professionals also undertake what we call legal research and analysis. Just as social sciences and anybody conduct research, legal professionals also undertake research because they need to do a lot of research to know cases that has been adjudicated upon, so that they can get that, okay, this case, this is what happened. If a similar case comes up, just like legal precedent or stare decisis, then I can also have ABC to also apply to it. So lawyers or legal professionals also undertake what we call legal research. Legal professionals also undertake what we call drafting of legal documents. If you have an indenture, it is the lawyer's role or the lawyer's responsibility to prepare an indenture for you. Don't go and prepare an indenture from a roadside commissioner for oath. They are not lawyers. They don't understand legal terminologies. It is only when issues come up, that is where you get to know the relevance of a lawyer. People, when they are preparing wills and other things, they just walk straight to commissioner for oath, because he knows that if a lawyer is going to prepare a will, he's going to charge him or her. So he will prefer to use the commissioner for oath, or he prefers to walk to the court to get a court staff prepare the will for him. Fine, you get it at a low cost. But mind you, wills come into effect when the person is dead. And when you are dead and you are no more, you are unable to talk. That is where there will be a lot of litigation behind you. Because these people are not lawyers and they do not understand what should go into writing of a will. You prepare a will, you think you have a will. When you die, lawyers will come fighting, and then they will come and set aside the will that you prepared. Because why? It does not meet the requirements of the law. These are key things that you need to do when you are preparing contract agreement, whatever agreement of any form. You have to engage the service of a lawyer. Never trust anybody. You see, when people are entering into contracts at the initial stages, everybody is a good person until you get into the middle. But when you get into the middle, the person will not come and say, oh, I said this and I said that. Oh, I didn't even say this. I didn't say that. And a whole lot of dispute will arise. No. Lawyers or legal professionals also help in negotiation and mediation. And so legal professionals are not only litigating in the courtroom, but they can also help you break some deals, okay? As clients, legal professionals can help you mediate some disputes. If, for instance, in divorce issues, professionals may come in, legal professionals may come in, lawyers may come in to mediate between the parties. We sign some terms of agreement or terms of settlement, and then we are gone. We don't need to always have to go and litigate everything in court. And then there's also the element of litigation, where you go to court, you present your case, witnesses will be presented, and then you examine the witnesses and you make your arguments. That is the litigation aspect of what lawyers do.
Sir.
Yes.
Sir, please, I want to ask, so what happened between Kwesi Arthur and his record label is under hot?
I did not follow that case. Unless
because
you give me...
According to the case, they said he can't use his own image to do anything. According to the contract he signed with his label.
Okay, so what it means is that possibly he might have signed a contract without the presence of a lawyer. And so they just brought him the contract. So he signed. Because if he was represented by a lawyer, the contract, and would have read it to him that this is what it means, and I'm sure he might not have signed. But once a contract has been prepared for you, you have signed, it means you are binding yourself to it. So anything that happens, you'll be bound by it. That's why it is important that you always have a lawyer, because as a musician like that, sometimes they are looking at the money that will go down the drain, because they think paying a lawyer may not be necessary. Fine, it may not be necessary, but at the point when it matters the most, you will get to know that when the harm has been caused, you spend more seeking for the service of a lawyer to go and do litigation on your behalf, which that one is not even assured 100% that you are going to win. Okay? Meanwhile, you would have spent something small on a lawyer to go through your agreement for you before you signed. I did not follow that case, but I think I heard something like that. But so I don't really know the content of the case itself.
Okay, sir.
All right.
Thanks for the clarification, sir.
All right. And in the field of practice of law, like I've said already, we have various branches. You can do criminal law, you can do company law, you can be a corporate lawyer, you can be whatever, divorce lawyer, you can do environmental law, you can do family law. We have so many areas of law. We have taxation law, we have minerals law, we have so many areas or branches in law that a person can enter into. And the significance of these legal professionals in our society is to uphold justice and advocate for people's rights, as well as to preserve the rule of law, so that lawyers hold people accountable. Okay? And there should also be what we call conflict resolution. There must be a built expertise of legal professionals so that they can help in resolving conflict. it is not every conflict that has to go through the court system. It's so tiring. It's so cumbersome. Sometimes you can just, two parties can just sit, their lawyers can just sit and agree on something. It is not every case that you have to be going to court, because it is so tiring that you have to pay the services of a lawyer. You'll be going to court every now and then. You have to pay the lawyer's transportation. You have to pay for filing fees. You have to pay for this. But if you agree, if there has to be some mediation or negotiation, there's an agreement, you agree, you don't go through all those processes. It becomes a little bit cost effective for you as a client. And then it also contributes to social progress, because legal professionals, they end up driving what we call positive social change. Any question? Any question?
Hello, sir.
Yes.
Sir, my question was, you were talking of the assault.
Okay.
Now, if you go to a police station to report a case on assault, they may take your statement, fine, and arrest who assaulted you. But here is the case. The family of the assaulted person will come and they say, we want to resolve it at home. Meanwhile, you said when you assault someone, it's not between the complainant, but rather with the government or the nation. So why is it that some people will come and say they want to take it home and settle it at home? Is it possible?
Oh, yes, it is possible. We are in Ghana, and as part of our customs or as part of our tradition, normally people want to step in to resolve matters. Yes, fine, it's an offense against the state. No two ways about it. But you should also remember where we are as a country. And normally, you see, if such cases go to court, the outcomes are either that you pay a fine or you can be sentenced. Nobody wants to see anybody go to prison. Okay, nobody is interested in anybody going to prison. The essence of criminal law is to ensure law and order, to maintain order. And so if the family comes in and say, oh, we want to resolve it, okay, it's to help the mediation process, for the person to know that what he did is not right. And so next time the person will be very careful. Okay, so that's why sometimes they may come in to help in the resolution of all these things. Just that the person doesn't get punished for whatever offense that the person might have committed. Yes, Benjamin.
I wanted to add up to what the question that she was asking.
Okay.
And also, before the case will be withdrawn, or if family comes in and the complainant is saying that no, I want the issue to go to court. As for that one there, nothing can be done away about it. So that one would depend on the complainant. If the complainant agrees that, oh yes, I want her to settle the thing at home, then he will go and draft a withdrawal statement to police. Then you come and withdraw the case from the police station.
Yes, exactly. Because even though the offense is against the state, at the end of the day, you will need the complainant to go to court to testify as a witness. And if the complainant who is going to testify for you, the police, who is the prosecution as your witness, says, I am not coming, how are you going to prove your case? The person who was assaulted said, I am not coming. So you will not be able to prove your case. So normally when the complainant says, okay, we want to settle, the police would allow them that, okay, go and settle. Then later on, the case will be withdrawn. But the case will be withdrawn. I'm sure normally sometimes they may ask for some compensation, okay? Because if it goes through the criminal justice system, you would notice that even if there is a fine, if the penalty is a fine, that fine is not coming to you, the complainant. It is not coming into your pocket. So Meanwhile, you are the person who was assaulted. You are the person who suffered for it. You are the person who had ended up spending money to go and buy paracetamol and all those things just to treat your headache and whatever assault that you suffered. And if you are taken to court and the court says pay 200 penalty units, the money is going to the state. It doesn't come to you. So in the interest of you getting something, I would prefer that I would resolve it with the person and allow the person to pay me some compensation so that at least that money I can use back to buy some paracetamol and then put some in my pocket, rather than for the state to go and take the money and I will not get anything. So sometimes that is how these things also work. Okay, so
But another problem I'm having is, can you please come out on the difference between rule of law and equality before the law?
Okay, so the difference with rule of law is that you want to hold every agency, okay, every person in the country accountable to whatever they are doing. Okay, so the president spends money, you want to hold him accountable. That is why the president would go to parliament to render account at the end of every year. Okay, and equality of law simply means that every person in the country is equal before the law, such that we don't have law A being applied to the rich and law B being applied to the poor. It is the same criminal law that we have. So if a rich man steals and a poor man steals, it is the same criminal law that is going to deal with these individuals. So that is the equality of law and rule of law. Is it okay now?
Yes, sir. Thank you.
Any hand up?
Yes,
okay,
sir.
Benjamin.
So when, let's say, someone is being assaulted and the case is taken to court, so that means nothing will be given to the complainant, right?
Yes, mostly you would.
Fine. Nothing will be given to the complainant as to like when to add the cost incurred in like the medical bills.
Yes. So normally the offense is against the state, and then it is the monies that will be paid to the state. Sometimes you may have some judges saying that, okay, you have to foot the medical bill of this person. Okay. You may have that, but that is really not the way sometimes it is just out of fairness that they do so. But normally, because the law, for instance, if it is assault, the law has provided for the penalties, and as part of the penalties, medications or whatever is not part of it. It is fine or imprisonment. Okay, and so sometimes, just to be fair, that's where you have some judges coming in to say, okay, then pay the medical bill of for X or pay the medical bill for Y. So sometimes it's just on fairness purposes that the judges uses their discretionary powers to do so.
Okay, sir.
All right.
Then it's better. Okay, that's why mostly they do resolve it at the police station, because that one, after you pay, after they find your medical bills, they will compensate you in addition.
Oh yes, of course, because I would prefer, in such cases, I would prefer to resolve it at the police station by getting some compensation and you pay my bills. But sometimes you want the person to be punished. Okay, you want, because it could be that is not the first time the person is doing so. Okay, and so you want the person to suffer some punishment so that the person doesn't say, oh, because I have money, I can just go and resolve it at the police station. Sometimes people will not take the money. They want you to be punished. You want you to go and face the law. Okay, so next time you don't do such things.
Okay.
So we are looking at the last part. We are looking at the last part for the day. And what we are going to do is enforcement and legal remedies as upholding the rule of law. How do we enforce the law. How do we enforce the law? And what are the remedies available to us? That is what we are looking at. Who's this thing is on? Is it Benjamin? Yeah. So please mute your system. Yes. So in terms of law enforcement, I've already indicated to you the various agencies or institutions that are mandated to enforce our laws. And this you already know. The police, they are the key law enforcement agency to ensure that our laws are working, to ensure that public order is maintained. So the police will always tell you our core job is is to protect life and property. Okay, DS is to enforce the law so that people don't abuse others' rights. It's for public safety purposes, and they also want to uphold the principles of justice. That is why they are saying that they are the law enforcement agency. We also have another law enforcement agency. It's not a law enforcement agency per se, but the judiciary also play a key role in enforcing our laws one way or the other. And how do they do that? They do that through their court orders and judgments. Okay, so if the court grants an order or gives a judgment, it becomes an enforceable judgment, such that people will enforce it. If there is an injunction, then the parties have legal obligations to comply with the judgments of the courts. There is also what we call regulatory enforcement. Regulatory enforcement simply means that we have certain institutions that the executive have set it up to provide regulations for people to respect and to comply. For instance, we have FDA. You know that FDA, as part of their job, they have to come up with regulations towards the protection of people's lives. This time around, not like protecting lives in terms of the police, but protecting lives in terms of the food, okay, that people will consume. And so they have to come up with regulations to ensure that any food or any item, okay, that is being consumed into our system, medicines, whatever, anything that is expected to be consumed, comply with standards. So they also come up with these regulations so that they are enforced to protect the safety of individuals. We have the environmental agencies also as well. They're also involved in regulatory enforcement. We have the National Pensions Regulatory Authority. They're also a regulatory enforcement agency to ensure companies are paying for the contributions of their workers. We have GRA also to ensure that people are paying their taxes. So these are all regulatory enforcement agencies. They are all government agencies playing key roles. In terms of remedies, I've already discussed this. When you have a civil case, there are remedies that are available to you. You have specific performance, injunction, you have compensation, you have damages, okay? And we also have declaratory reliefs. These are to ensure that people's harm or the violations of their rights are addressed, so that when somebody violates your right and then the person is compensated, at least the person will feel some sort of a little bit relief. But imagine somebody has abused your right and you receive no compensation or you receive nothing. How will you feel? Very bad. And so these civil remedies are in place to ensure that people get what they suffer from. Now, we also have what we call criminal remedies. Criminal remedies. Now, these criminal remedies, mostly they are the penalties or the consequences that are imposed on individuals who are found to be guilty or who are found to be convicted of a criminal offense. So, like I've already said, normally you have fines, you have imprisonment. Sometimes you may have probation or community service. But in Ghana here, community service, I mean, I don't think we have not passed that law yet. And so, but in other jurisdictions, when you stand trial, or when you engage in any criminal act, you may have some community service that as a penalty. You may have community service as a penalty. Sometimes they may organize some rehabilitation program for you, especially when it has to do with persons taking drugs and a whole lot of things. They may have some rehabilitation programs also for you. The essence of these criminal remedies are to ensure that criminal behaviors or people who engage in criminal behaviors do not do it again. These laws are there to serve as what? Deterrent to others. Because if you assault somebody and you go to prison for 4 years, it will be a lesson. I'm sure next time, because you have seen that somebody has gone for 4 years, next time you are very careful when you want to assault another person. Then we also have what we call equitable remedies. Those ones I've already spoken about it. We have what we call administrative remedies. So these administrative remedies, normally they include appeals, reviews, and administrative hearings. So for instance, if NPRA, National Pensions Regulatory Authority, have found you guilty that you've not been paying the pension contributions of your workers, but you disagree with them, there's an administrative remedy that you could do, you could use. You could go to court, you could have an appeal, or you could have a review of their decisions. So these remedies exist to help individuals. It exists to help the party, so that GRA does not just sit somewhere and say, oh, you've not paid your tax, so we are punishing you, blah, 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 blah. So these remedies are important, and they exist to protect the rights of individuals. And we also have rectification and restitution. Okay, that when somebody commits an offense against you, for instance, assault, you may want to restore the person to the position that the person was at the time of the assault through compensation. And you may also want to, sometimes when it comes to rectification, we are talking about contracts. Okay, these are equitable remedies, especially for rectification, that if a contract is bad or something, the court can come in for rectification to be done. And so normally, you see, all these things, these equitable remedies or these administrative remedies or criminal remedies, whatever kind of remedies, the interest of it is to ensure that there is justice in the system, is to ensure that there is order, social order within the society, is to ensure that people just don't misbehave or do whatever that they want. Because if we don't have remedies, sometimes people go to prison for no offense committed. Sometimes it is likely that a judge may be wrong. People are in prison not because they have done A, B, C, D. Sometimes judges are wrong. They might have sentenced these people wrongly. And so when such people appeal and they become successful, they are supposed to have some form of remedies. Okay? The state is supposed to compensate them with some amount of money for being in prison for this while when they had not committed any offense. So these remedies all exist to ensure that people's rights are not trampled upon. And they also exist to ensure what? Justice, like I've said, and to promote accountability. Everybody must be accountable to whatever they do. And there must be fairness, order, and the rule of law, as we said, has to prevail at every point in time. So on this note, I would ask if you have questions. I will take your questions from whatever we have done so far. If you have no questions, then I presume you understand whatever has been taught. And so it is important that you go through the first chapter, which is the Unit 1. And I'm sure when you go through Unit 1, you would understand exactly what I have taught for the day. So I would welcome questions, any question at all. It could be on the legal principles, it could be on enforcement, it could be on the legal system, whatever question that you have. Sarah.
Yes, sir. Hello, sir.
Sarah. Okay, all right, Prince.
Good evening, sir.
Yeah, good evening. I'm listening.
So, with regards to when we're doing the international treaties,
Okay.
yeah, with the issue, the case of Oforiatta, why is the US still holding him? Or is it because of his immigration issues?
Yes, the US is holding him because of his immigration issue. So his immigration issue over there is a public law issue. Okay, he has to deal with it first. Okay,
Oh,
it's more or less like he is in conflict with their law, and those are their public law, okay, or their
okay.
domestic law, and so he has
Okay.
to deal with it first. Then after he's dealt with, then maybe Ghana can also now go in, and then he can be extradited to Ghana for him to face his charges over here. So for now, what he's
Okay.
going through is just like somebody else has committed an offense in Ghana here, and the police are holding on to that person because the person has gone contrary to the country's law.
So let's say the outcome, it comes out that let's say he's guilty over there. That means he's going to serve a sentence there before he will be extradited to Ghana, right?
I don't know what their law says, but if their law provides for sentencing, yes, he will be listened to. I mean, a judge will try the matter, and then the outcome of it, he will face the consequences. It is likely, for instance, after going through it, Ghana can say, okay, he also has another case over here that he has to stand trial for. So he could be extradited back to Ghana. But if the offense that he's standing for is let's say is criminal in nature, which has, let's say, about 3, 4, 5, 6, 7, 8 years imprisonment, he would have to serve his
Okay.
sentences first over there before then
Before
afterwards
he'll be
he's brought
extradited
down.
to Ghana.
Exactly. Then he's brought down here. But immigration issues, I
Okay.
don't think he should serve any sentence.
Okay. Thank you.
All right, welcome. Any other? I can see Charity. Hannah. Emmanuel. Philemon. Sarah.
Sir,
Sir,
Any question?
no, sir, for now.
Okay, all right. So if there are no questions, then we will meet next week.
Okay, sir. Thank you
Okay, I
very
think I
much.
see a hand up. Benjamin.
No, I was clapping.
Okay, okay, all right.
Yes.
Thank you very much, sir.
Wow.
All right, so I'll see you
Thank you,
next week.
sir.
The class has been
All right.
a lovely one, so thank you very much.
Thank
All
you.
right. All right, thank you too for joining.
Bye.
Hello.
Why
Hello.
The lecture is gone.
Well, I thought the first letter was Mr. Wa. But later,
Okay.
I heard 2 voices at the same time. Then, did you also face the same problem?
Okay. Please,
Sarah.
Yes.
Sarah.
Yeah.
Sarah,
Please, hey, look at me, no.
can you introduce yourself?
Hello.
I'm a
Can you please
Sasha.
introduce yourself?
You are
I'm a
12.
Sasha. Pardon?
Oh, okay. Then you join our the Accra link. Hello.
Okay, well, later I heard two people at the same time. I heard this
Hello.
letter and Mr. Wa at the same time.
That means you copied the same link. That link was for Accra. Like we those at Accra. Our lecturer couldn't meet us face to face, but his link is there. So I'm sure that's the link that you followed.
I used. Okay.
Uh,
So this
And then
is
go
one.
online.
yeah. So you've missed your original class, but all the same.
You've
Me and I
enjoyed this
we
one.
I don't know.
I see.
You are
I
lost.
I'm talking with. I don't know you people. I'm not familiar with you people. Okay, thank you. Next, I will enjoy your class. Bye bye.
Okay, bye. Airport mine.